Good morning, everyone, and welcome to WorkCover Queensland's Common Law webinar on the topic of workers' compensation in the hybrid work environment. My name is Tim Loos. I'm a Senior Lawyer at WorkCover Queensland, and I'll be your host today. Before we begin, we would like to acknowledge and pay respect to the Yagara and Turrbal peoples as the traditional custodians of the land in which we work. We thank them and their elders past and present for their ongoing connection to land, waters, culture and community. Joining me in the room today at WorkCover Central is our guest presenter, Yvette McLaughlin from Sparke Helmore Lawyers, and we also have Elise in the room from our communications team who'll be running the webinar today through Teams. Some housekeeping. We record these sessions and we will later send out a link to you all to the recording along with the slides, and we send out a short survey as well to get some feedback. The recorded sessions also go up on WorkCover's YouTube channel where all our past webinars are as well. You can find them all there for free. During the webinar today, please feel free to submit questions. There's a Q&A button in the toolbar at the top of the screen. If you're not logged into Microsoft and can't use the Q&A button, then please submit questions via the chat function, and we'll do our best to answer your questions at the end of the webinar. We've also got some that we received upon registration, so questions in advance that we'll incorporate into the end on a slide. Just a reminder, we can't answer any policy or claim specific questions. If you do have any specific questions, please speak to a customer advisor or a relationship manager that you've spoken to at WorkCover before. Finally, if you have any technical issues, please refer to the help information under the More button, which is at the toolbar at the top of the screen. Right, today's guest presenter, Yvette McLaughlin, is a partner in the Statutory Lines Insurance Group at Sparke Helmore Lawyers. She is an accredited specialist in personal injury law and has been defending workers' compensation, common law and general insurance claims since 1996. Welcome, Yvette. Before I hand over to Yvette, one last thing. I would just like to remind everyone listening that any information provided, including in response to questions answered today by WorkCover or by Yvette, is just general information only and not to be taken as legal advice. That's all from me. Thank you very much. I'll pass over to Yvette to start.
Thanks very much, Tim. Thanks, everyone. This is an interesting topic to explore today. Certainly, since the pandemic, the lives of most employers and workers have been impacted in some way by COVID, and the ripples of the pandemic and its impact on work practices continue to resonate and will have long-term consequences in the workers' compensation space. The evolving work landscape that we've seen since 2020 will also continue to challenge both employers and workers, with the hybrid work model persisting and technological advances challenging the traditional employment landscape, including the rapid advancement of AI. The topics that we will consider today include some contemporary issues in the context of workers' compensation and within the framework of the workers' compensation legislation, including vaccine injuries, the COVID landscape itself, what injuries in the course of employment look like, journey and break claims, particularly in the context of work from home environments, the risks and benefits from working from home, workplace mental health now and into the future, and generally what does the future look like in this space. In terms of COVID-related claims themselves, the applicable legislation in Queensland, both in relation to statutory benefits and common law claims, is the Workers' Compensation and Rehabilitation Act 2003. The Act, of course, contains definitions applicable for the definition of injury, and I'll run through some of the statutory provisions today just so that we can re-examine those in the light of the hybrid working environment that we find ourselves in. Section 32 of the Act provides for the definition of injury and confirms that an injury is personal injury arising out of or in the course of employment if the employment is a significant contributing factor to the injury. In the context of COVID and other diseases, Section 32(3) specifically provides for a disease contracted in the course of employment, whether at or away from the place of employment, if the employment is a significant contributing factor to the disease. Historically, proving the contraction of diseases such as perhaps Ross River fever and now COVID occurred during the course of employment, and that employment was a significant contributing factor to the disease can be challenging, as the injured worker is, of course, commonly exposed to the risk of infection both during the course of employment, but also in their private lives. But sometimes it is apparent on the balance of probabilities that the infection was contracted in the course of employment or perhaps at a place of employment. For example, there may be a documented outbreak of COVID, or the worker may have been on an extended work placement in a tropical area where Ross River fever can be proved to be present. But certainly these sorts of diseases and injuries do prove a challenge in this environment. In terms of COVID-related claims, the definition of injury also includes a psychiatric or psychological disorder. We highlight on the slide the exclusion for reasonable management action, which may become relevant in consideration of a claim for psychiatric injury arising from a vaccine mandate or the administration of a COVID vaccine. I highlight specifically subsection 5, which provides that an injury does not include a psychiatric or psychological disorder arising out of or in the course of any of the following circumstances, and particularly subparagraphs A and B: reasonable management action taken in a reasonable way by the employer in connection with the worker's employment, and the worker's expectation or perception of reasonable management action being taken against the worker. So the historic examples there in respect to reasonable management action include an action taken to transfer, demote, discipline, redeploy, retrench or dismiss a worker, and a decision not to award or provide promotion, reclassification or transfer of leave of absence or benefit in connection with the worker's employment. It is apparent, therefore, that those provisions can translate into the areas of vaccine mandates, mask wearing within the workplace, and other issues that we have seen arise during the pandemic. And we certainly are seeing the ramifications of those matters continuing. Although there have been some recent decisions around whether the vaccine mandates imposed by employers were unlawful, the recent decisions have been based on a failure to consider matters such as human rights, and many decisions have been held to be reasonable in the circumstances requiring workers to either be vaccinated or to comply with mask mandates. So we did want to highlight in the slides there a number of cases relevant to the issue. Come back to some of those cases later in the paper, but in JKICH, it was found that the public health order requiring the mandate was the major contributing factor for the mask requirement, and that the mandatory direction was not in effect made by the employer themselves. Certainly in nearly all cases, the directives for masks and vaccines by employers are in response to public health concerns or directives. However, the requirement that management action be taken in a reasonable way means that it is still incumbent on employers to follow legislative requirements prior to requiring workers to be vaccinated or to wear PPE such as masks, and also to communicate their decision and to consult with workers in accordance with their own policies and procedures, as well as any overriding legislative requirements. As always in this area, each case will turn on its own facts in respect to whether the mandate itself is lawful and whether it has been communicated in a reasonable way to the workforce. The Markovich case was not finally determined, but it was alleged that there was a failure to properly enforce the use of masks and gloves, resulting in a worker dying as a result of contracting COVID. So it's not only the mandates that are in issue here, but the duty on an employer to ensure that there is the provision of a safe workplace, and a failure to enforce a vaccine mandate or mask wearing may also potentially expose an employer to claims for infections contracted by workers within the course of their employment. Although perhaps less topical at the moment, there is still the potential for direct vaccine injuries to result from either an original vaccination or for booster shots that we are seeing and result in vaccine injuries to workers. The evidentiary difficulties associated with the contraction of a disease also apply in many cases with respect to the alleged vaccine injuries, and also in many cases to alleged psychiatric injuries resulting from both the mandates and the vaccination process, particularly when the outcome of a COVID infection may also be significant and result in similar symptoms to a vaccine reaction. Just highlighting again a couple of the cases. In that first matter of Yuzanovska, a teacher suffered a psychological injury from her employer's communication of a COVID vaccine mandate. In that case, workers were sent guidelines stating that unvaccinated staff may face disciplinary action, including termination of employment. Essentially, the worker in that case opposed the directive. She saw doctors and specialists about her stress and anxiety around the vaccine, and also stated that she felt stigmatised, bullied and harassed by her colleagues over her choice. In that case, the appeal by the employer was dismissed as to whether that action was reasonable. In terms of Shepherd and South Australia, the worker in that case was a child and youth support worker required to be vaccinated. Unfortunately, after his third dose, he experienced extreme pain and was diagnosed with post-vaccine pericarditis, which is swelling and inflammation around the heart. It was found that the injury arose as a result of both a vaccination mandate as well as the applicant's employment, and that Section 7 of the Return to Work Act 2014 in South Australia, again also similar to the Queensland legislation, required that employment be a significant contributing cause of a work injury, but not its only or most significant cause. And in that case, Section 7 was found to be satisfied. There's also been a number of claims and cases after employer implemented vaccine mandates. In Dorking and Secretary, Department of Education in New South Wales case, the member stated that the way the respondent employer implemented the public health order was not reasonable. This included the fact that the respondent did not consider the potential impact a termination of employment may have on the injured worker's re-employment once the public health order requiring the vaccine had ceased. There's a similar outcome in Davis and Department of Education. Again, a focus on whether the employer had taken reasonable action with respect to either discipline or dismissal as a result of the proposed mandate. The cases that we've seen have concentrated very much on also the aspects of dismissal of employment, not always about whether employment has been a significant contributing factor. But certainly they do confirm that compensation may be available for psychological injuries resulting solely from the vaccine mandates, but there has been a heavy focus on whether an employer has taken reasonable action with respect to discipline or dismissal, and this is likely to very much invoke the reasonable management action provisions of the Workers' Compensation and Rehabilitation Act in the context of any claims for either compensation or damages. In Triplo and Leidos, the claimant there were employed as a drop master at Cairns Airport, and again there was a vaccine mandate from the company. Triplo had submitted medical exemption from compliance, and the employer thought it was insufficient, and on that basis had terminated the employment of the worker. In that case, the worker's complaint was dismissed. In De Bruin and State of Queensland, again, there was an exemption sought from compliance with the vaccine mandate, and the employee had been suspended without remuneration. And again, in that matter, the claim by the worker had been dismissed. In Endicott and State of Queensland, the appellant had not complied with a vaccine mandate, but that appeal has not proceeded. So we haven't seen a particularly high rate of success from workers challenging the vaccine mandates, particularly in Queensland, but there has been a lot of recent publicity around the more recent decisions in both Queensland and New South Wales around whether some of the mandates imposed, particularly by the public health departments and the government departments, have complied with all of the background legislation, including human rights. And so that will continue, I think, to be something that we'll see litigated into the future. So moving now a little away from the COVID provisions and injuries and more into what a hybrid work environment might look like and what work from home is impacting in this space. I wanted to consider the definition both of, again, the definition of injury, but also the definition of place of employment. And I've put up there the definition, meaning the premises, works, plant or place for the time being occupied by or under the control or management of the employer by whom a worker concerned is employed, and in, on, at or in connection with which the worker was working when the worker sustained injury. You will recall that injury is defined as personal injury arising out of or in the course of employment if the employment is a significant contributing factor to the injury. It is therefore arguable in the context of a work from home environment that a worker must be engaged in a task of their employment in the event of an injury being sustained at home. However, I will loop back later to the requirement also that if a task is encouraged or prescribed by an employer, then it may be outside that specific task of the employment, such as perhaps office work in their usual day-to-day environment. Some injuries, such as an ergonomic injury resulting from a less than optimal desk setup, are likely to be less controversial in the home environment. However, I've been able to think of a number of nightmare scenarios which will be more problematic, people falling over their dog, an injury in the kitchen, electric shock injury from equipment which may be owned by the employer but which they are using for their work tasks. I've also highlighted there the section 33 in respect to the application of those definitions that I've highlighted. And the Act makes it quite clear that the subdivision does not limit the circumstances in which an injury to a worker arises out of or in the course of the worker's employment. Therefore, it will be important in each case to look both at the environment in which the worker is undertaking the tasks of their employment, what control the employer has over that environment, and what risk assessment and other matters have been considered with respect to the work that's being undertaken. So certainly there really is no limit on the number of ways in which a worker may bring themselves under the Act or within the course of their employment. So just highlighting there in terms of recess claims, section 34 of the Act. And again, an injury to a worker is taken to arise out of or in the course of the worker's employment if the event happens on a day in which the worker has attended at their place of employment as required under their employment contract. And again, looping back to that previous section, the place of the employment really does mean an area controlled by the employer. So unless the worker is injured at their place of employment or while they're away from the place of employment in the course of their employment, so perhaps driving, delivering outside of their office environment, or under paragraph C there, while the worker is temporarily absent from the place of employment during an ordinary recess. But specifically, if someone is absent from their place of employment, either perhaps having attended their office in the earlier part of the day, or if they've left their work environment, employment in that scenario need not be a contributing factor to the injury. So specifically, if someone injures themselves on their lunch break. So you can see from those provisions that an injury at home is not automatically within the course of employment. Regard must therefore be had to the nature of the worker's employment and whether the worker is engaged in tasks of their employment at the time of injury or furthering the employer's business at that time. So similarly, in this space, it's worth revisiting the provisions in respect to journey claims. And again, unless an injury occurs on a journey to or from the worker's place of employment, that is a place controlled by the employer, taken during the course of the day by a worker. So you can see, therefore, that there'll be, again, that loop back to whether or not the employment is a significant contributing factor to that injury. But in that context, if a worker is driving to collect perhaps office supplies, either at their place of employment, which would pull in section 35, or at Officeworks or some other equipment supplier to allow the worker to undertake their work and to further the employer's interests, then it may be argued that an injury on a journey could be in the course of that worker's employment. And we'll come back later to some cases like PCYV and Comcare, and that is the provision that allows the tribunal to look at whether a worker has been encouraged or allowed to undertake the activity that they were doing at the time of their injury. So again, in that context and looking at potential scenarios, if an employer encourages workers at home to exercise or take a break during the course of their day, or to perhaps meet up with other workers for a walk or other activity, it is possible that this may become either an ordinary recess claim or simply an activity encouraged or allowed by the employer, which may bring it within the course of employment. Again, looking at those scenarios, though, mowing the lawn at lunch would be unlikely to be an ordinary recess and may constitute subjecting someone to an abnormal risk of injury outside what could be furthering the interests of the employer, and therefore arguable that it's not within the course of employment. So this brings us to the consideration of what is a workplace. And there's been a couple of cases on that in terms of what happens to someone in their accommodation. Some of these obviously predate COVID, but it's worth looking at those in the context of the environment that we find ourselves in now. In Australian Frontier Holidays and Williams, it was found that the respondent worker had suffered an electric shock on the steps outside his place of residence in the course of returning for the purposes of retiring for the evening. So in other words, had finished work for the day. In that case, the accommodation unit was provided by the employer on the boundaries of land upon which the employer conducted a motel business. And at the time of the injury itself, the injured worker's presence at the workplace was related to his work, and it was held there existed a substantial continuity in the sense that the worker's presence at that place at that time was directly connected to his work, and that was an accepted workplace injury in the Northern Territory under their Work Health Act. I've included there the definition of workplace with the Work Health and Safety Act, and again that's worth bearing in mind in terms of the employer's obligations in this space. A workplace is defined as a place where work is carried out for a business or undertaking and includes any place where a worker goes or is likely to be while at work. So that obviously is a very broad definition and certainly encompasses any work that a worker may be undertaking for you from a work from home basis, but potentially also in temporary accommodation or even, as we'll loop back to with the questions, on holidays. So in that section specifically, the Act also includes any vehicle, vessel, aircraft or other mobile structure that a worker may be in at the time of injury, and any waters installation on land, on the bed of any waters or floating on any waters, which has always intrigued me a little bit, but clearly it is designed to pretty much include anything that a worker may be doing where they're undertaking the duties of their employment. Unfortunately, there's nothing too substantial in the Workers' Compensation and Rehabilitation Act itself to really assist with those considerations further, other than the definitions that I've already highlighted. There are some provisions for work that may be being undertaken interstate or overseas, and certainly the Act makes provision for any temporary absence from the state in respect to any injury that may be sustained. Moving now then of a broad consideration to what the risks and benefits of working from home look like, both for the worker and for the employer. And certainly the Work Health and Safety Queensland and the other health providers around Australia have certainly been pulling together this list substantially over the last couple of years. The risks include the potential for inadequate and inconsistent working environments, poor workstation setup, poor work environment through either lighting, noise, temperature, lack of ventilation, utility outages, etc. And certainly within that space, we are seeing still a lot of people working from home in really, I suppose, temporary setups, people working from their dining room tables, people working on their children's tables. So really quite a potential there for exposure to non-ergonomic environment within the home environment. There's an increased cost of resources, both for the worker and for the employer, having a split workplace. A lot of workers have been provided with additional technology in the home environment to that which they may use at their normal place of employment. There's the potential within the home environment for distractions from neighbours, council work, family and friends, also deliveries outside the work environment, and of course the temptation to do things within your own home for short or long durations throughout the day. It's quite common, unfortunately, for workers in the home environment to be using subpar equipment such as office chairs, computer stands, which may create pain and injury, particularly over a longer period of time. And in my view, this is probably an increasing risk for a lot of employers within this environment at the moment. We're seeing the work from home environment becoming entrenched, and it's likely to be a long-term proposition for many employees. So the risk posed by the ergonomic environment may actually increase over time. And there is a potential, obviously, for period of time claims to result from those ongoing conditions within the home environment. There's also the swapping back and forth between different ergonomic arrangements at work and at home, which may not be considered specifically in many risk assessments. There's obviously trip and slip hazards within the home environment, just from people's own environments such as toys, pets, maybe again those temporary cords setting up their home office environment. And ongoing psychosocial effects are potentially significant, including low job control, poor support, low role clarity, onboarding workers into an environment where the employer may not have much control over. And unfortunately, the potential for workers to be exposed within their home environment to other risks, including family and domestic violence. And there has certainly been a case in New South Wales where there was a worker charged where unfortunately both parties were working from home during the pandemic, and it has resulted in domestic violence situation. Again, workers are working in their home environment in a sedentary capacity with little or no supervision and can sit still for very long periods of time or work perhaps from their couch, not moving, and certainly that creates the potential for an unsafe work environment. As you'll see a little later, in terms of psychosocial health, there's now the potential for people, particularly if they live alone, to be going many days without speaking or talking to anyone within their home environment, communicating perhaps just with chatting on their computer or simply not communicating with anyone at all. And there's a potential there for a gap in management of both workers' physical and mental health within the home environment, and certainly ongoing issues stemming from isolation and disconnection, particularly if someone is working either many kilometres or perhaps in a different city from other workers within their employment environment. Office and personal space becomes one, and certainly there's a little bit more awareness now of the inability for workers to be able to switch off from their work environment in the evening or over the weekend, potentially creating fatigue from never being able to get away or log off from their work environment, and losing actually that break between work and home that may be available to people during their commute to and from the office environment. As a result, many workers in the home environment are working longer hours, and some tasks can only be completed in office with great barriers surrounding the tasks, such as physical signatures, which may be creating additional stress within that environment. All of the factors that I've just discussed can also be potentially linked to lower productivity, impacting employers in that environment. We're also seeing, I think, an increasing risk in respect to attempted mandates for people to return to work, and certainly there's been a lot of publicity around that in terms of, again, the way that might be communicated to people within a reasonable management action environment, what people's responses are to that, and whether they can be forced back into a work from office environment. So that is actually a very complex area, and I think just an emerging area in terms of both risk and what reasonable management action will look like in that space. And certainly there's been some larger employers face quite a lot of adverse publicity in terms of their attempts to bring people back into the office. Benefits, however, from a hybrid work environment should also be considered. There is a reduction for workers in commuting time, which allows greater autonomy and flexibility, and certainly for many people with children or other family commitments, that can bring a very great benefit to their work environment. And some people feel they can achieve a better work-life balance and higher productivity without the distractions of colleagues. Certainly in winter and at times either of increased COVID or flu environments, it can reduce the spread of sickness and illness, particularly for workers who maybe have other vulnerabilities in terms of their general health and well-being. Ultimately, in the future, employers may have smaller costs for office spaces and resources. And certainly the adaptation into technologies such as AI and remote working have found that there's been an increase in use of digital technology during and after the COVID-19 period. And I'm told by our IT people that that's advancing at a pace that we couldn't have dreamed of perhaps 5 years ago, even with benefits being seen from productivity, but also the pace of work that can be undertaken from that. But the last dot point there, as I said, is the benefits from productivity are obviously more directed at employers, and workers tend to benefit from this less. And some workers can be noted to benefit through a better work-life balance and some flexibility. But I think, again, it's certainly worth employers monitoring people's workplace health, both in a physical and mental sense, both now and into the future. So just looking at what some cases might actually look like in that work from home space. There's an older case from 2016 of Damasi and Comcare. The applicant was working from home on the day of the injury and managed to become injured whilst running during a break from work. In considering whether the claim was reasonable, it was found that I would have thought it is beyond argument that going for a run during one's lunch break is doing something during an ordinary recess in one's employment. But taking a break for the specific purpose of going for a run at any random time of the day is in a different category. It is not a recess of the kind contemplated by the Safety and Rehabilitation Act, which is the Commonwealth legislation, much less an ordinary one. I must therefore reject the submission made on behalf of the injured worker that her run at 9:30 in the morning is indistinguishable by one that may be taken at lunchtime, on the basis that the lunchtime run is undertaken during an ordinary recess in the worker's employment, while a run taken on an ad hoc basis during the day is not, which I think is an interesting decision in terms of what that might look like from a work from home basis going forward, where certainly both the timing and nature of the breaks taken by an employee are almost entirely within their own discretion. In the second case there of Lubajewski and the Australian Federal Police, employment was terminated by the Australian Federal Police after the worker failed to comply with a lawful direction in terms from returning to the office. The worker had medical notes stating that he would benefit from working from home and that there was an ongoing conflict between him and some work colleagues regarding his physical attendance back in the office. In this case, the judge was satisfied that the dismissal of the worker for failing to return to the office was not unfair, and that dismissal was upheld in those circumstances. I'll loop back to the Charles Darwin one a little later in the paper. So just considering some specific cases on journey claims, I've just set out some, again, recent and somewhat older cases, but just to highlight some of the issues that may arise in this space. The matter of ISS Property Services and Laundess was a school cleaner. Her role was essentially autonomous, and she was able to self-direct when and where she completed her duties. On the day that she sustained injury, she had been performing duties near a school gate when she noticed that her car light was on and decided to exit the school premises to turn it off. In doing so, she tripped on a nature strip outside the school and sustained injuries to her spine, shoulder, hip, knee and elbow. In that case, the claim was upheld with the President Judge upholding the earlier decision that the worker, in essence, could authorise her own absence from the workplace in that scenario. In the very well-known case of Comcare and PVYW, which was the High Court case in 2013, the worker in that case had been staying in a motel when she sustained injury when a lamp broke and fell on her, essentially while she was undertaking extracurricular relations with another co-worker who was on the trip with her. In that case, ultimately, that application for compensation was allowed again in the federal jurisdiction on the basis that an interval or interlude in a period of work will be compensable if an employee is injured in circumstances that are connected to the inducement or encouragement of the employer for that worker to be there at that time and undertaking that activity. In other words, did the employer induce or encourage the employee to be there? That approach has been upheld on a number of occasions for people like flight attendants who may be injured overseas, walking in an environment outside their direct employment in circumstances where it has been encouraged by the employer to get out of the hotel and undertake some refreshing exercise. So the potential application of these provisions for being in the course of employment are very broad, and we have certainly seen expansion during the last 10 years. In terms of the recess claims, just highlighting a claim of Whittaker and QComp in 2011. In that case, unfortunately, the worker died from a heart attack in an accommodation unit while completing a layoff period. He was a train driver and the time between shifts for workers to rest and recover was obviously quite extensive. In that case, it was found that an 8-hour layoff was an ordinary recess for train drivers in those circumstances, again, being encouraged and mandated by the employer for safety reasons. So just again to highlight some more recent developments, and this is certainly applicable to workers in the hybrid work environment. The mental health and psychosocial risks, and this is a study conducted in May 2023, have found significant increases in the impacts of mental health, certainly an increase in mental health claims from pre-pandemic. And I think it's being understood more and more at the moment, the significant mental impact that the pandemic has had on all of the population, but also specifically on mental health of workers who may have been working remotely during that period. Workers are also facing cost of living pressures at the moment that may impact on their mental health. Again, specifically to be considered if they're working at home alone in a hybrid environment, that might not be particularly readily ascertainable by an employer that someone may be struggling in this area. Fatigue and burnout remains a problem across the board, and there's been a 39% increase in days taken off work due to mental health issues over the last 4 years, which is a very significant impact. So in terms of what that looks like for the future, the Australia's Workplace Health and Safety and Workers' Compensation ministers have devised a general strategy to protect the psychological safety of workers. That's a concentration at the moment for amendments both within Queensland and in other areas. According to the 2019 national report issued by the National Mental Health Commission, 45% of Australians aged between 16 and 85 will experience a common mental illness such as anxiety, affective or substance use disorder in their lifetime, and 1 in 5 Australians experience a common mental illness each year. So from these figures, it can clearly be seen what a significant risk mental health poses in the workers' compensation environment at present. In terms of what the future looks like after COVID-19, again, the Black Dog Institute and the University of New South Wales has studied the impact of COVID-19 on Australian adults, and over 5,000 Australians were surveyed in that study. 4 out of 5 of those participants reported their mental health had worsened during the outbreak and its peak. And again, 4 out of 5 experienced high levels of uncertainty about the future. Half of the respondents reported loneliness and worry about their financial situation. I think it's quite clear from the statistics that we are seeing within this environment and the studies that the regulators and workplace health and safety regulators within each jurisdiction are undertaking, that it will be very difficult for any employer to argue that they were not on notice, that it's a potential risk to their employees, both within the work environment at work, but also in a hybrid work environment at home, that there's a very real risk of impact on mental health in respect to the work that's being undertaken, and that raises expectations in terms of the response that should result from that. So specifically in Queensland, this has resulted in the Queensland Code of Practice for Managing Psychosocial Hazards. That's too big a topic for me to cover today, but I did want to highlight the presence of that Code of Practice and the potential impacts of that. The legislation commenced on 1 April 2023, so a little over a year ago now, specifically aimed to address psychological and psychosocial health risks at work. And very much aims to provide guidance to employers on managing risk within the work environment, and specifically to provide the means of guidance to employers about how to handle that and to apply the Code of Practice. The Code itself addresses control measures for psychosocial hazards and provides examples of psychosocial risks at work. That includes work overload, poor support, isolated work, workplace violence, and other hazards within the workplace. And specific examples are given within the Code for a number of different industries, including community care and smaller workplaces. But certainly there's very much a potential for this to apply to every workplace, including people working from home. Whilst that doesn't create a specific right to compensation, these sorts of codes and the responses to the risk inform what employers should think about doing in response both to the risk and in potential to a common law damages risk. So how to respond to all of this? Certainly be aware of your obligations under the Work Health and Safety Act as a person conducting a business or undertaking. Consider undertaking risk assessments of work being undertaken by workers either at home or outside their usual place of employment. Be aware of what employees are being induced or encouraged to undertake, both in their work environment and at home. Be mindful of the potential for psychiatric injury and what constitutes reasonable management action when controlling issues such as vaccine mandates, mask wearing, and of course return to work directives within the work environment. Be aware of the lack of oversight that you may have over an employee's actions and management whilst in the home environment, and consider the unique risks that are posed in the home environment. Really think about how you are monitoring an employee's wellbeing at home and how that is being reviewed and monitored. I'll just briefly mention the potential for common law exposure. Certainly an entitlement to compensation within the Workers' Compensation and Rehabilitation Act is a no-fault scheme, and many of the decisions I've discussed today are in that no-fault environment, particularly in the Commonwealth environment. But a worker may also seek common law damages in Queensland once they have been assessed for their injury, and that does require the worker to prove a breach of duty or negligence on behalf of the employer. But the issues in terms of the work from home environment and the risks that someone may be exposed to in that environment certainly give rise to the potential for a claim for common law damages. And I just set out there the general principles in respect to the duty of care owed by an employer in respect to the precautions taken for the risk of injury. So certainly a risk of injury at home is arguably foreseeable. It's not necessarily insignificant, and a court will look at what precautions a reasonable person in the position of the employer would have taken in those circumstances. Of course, a lot of the work that's being undertaken in the home environment does tend to be more office space, but as we've seen, there is that potential for ergonomic injury specifically, as well as more unique injuries such as electric shock injuries to arise in that home environment. Okay, so just in summary, in terms of what we consider as risks and potential issues in this area, obviously, the either completely work at home environment or hybrid work environment is a new environment for employers to consider, and certainly should be something that is addressed by way of consideration of risk assessment and issues such as that. There is an increased use of technology within the environment of home work. There's a potential because of that for 24-hour availability for employees and all of the risks and exposure that result from that. We do see, obviously, the continuation of other issues such as the gig economy, proposed amendments in that space, the psychosocial risks focus. There's ongoing blurred boundaries between work and home life, as well as documented heightened stress and mental issues since the pandemic. So unfortunately, this is a very dynamic environment that employers find themselves in, and they must identify and adapt to the new challenges posed by these changes within really the work environment that we find ourselves in from, say, 5 years ago. So that really is the main presentation. Tim has passed me the questions that we received beforehand, so I might just run through those.
These are the ones I noticed. I actually jotted down two things I wanted to just add, so if I want to maybe just give you a break in for a minute, just a couple of thoughts I had during the course of, so thank you for that. Just back when you're talking about the difficulties, I suppose, of linking virus exposure to employment, that's always a tricky thing. The thought I had there was, and if you've heard these webinars before, you might have heard me talking along this theme before, which is sometimes it's tricky. In those cases, it's tricky. Sometimes in all sorts of injuries, it's tricky linking injury to employment. But during the course of us determining the claim, what we need from you, the employer, is subjective information. So for, I suppose, with virus exposures, if there's been an outbreak within the workplace, tell us about that. As you would with any injuries, just give us the objective facts about what's happened and support our decision makers with the decision, because the more we know, the better. But I suppose try not to let opinion weigh into that as well. The other thought I had along the way, was that all of these things, working from home injuries, I suppose, it's nuanced and it's evolving. And there are obligations under the Act for employers to notify WorkCover of certain injuries if their workers hurt themselves. I think the test there under the Act, or the standard there, is if it's likely to result in compensation being paid. If you're ever in doubt, notify WorkCover, I think, because it's safer too that there's potential repercussions if you don't. So notify WorkCover, and I suppose don't ever discourage an injured worker from putting in an application for compensation. The worst we can do is deny it. We're the experts here in determining those statutory applications. So always support your worker if they want to put in an application, if they've hurt themselves in the course of their employment, and we'll determine it. Thank you. That was
Thank you. No, actually,
that's
interesting. And also, I think in that context, Tim, as well, the reporting framework that we're used to within our place of employment might also be a little bit blurred while someone's at home. So that might be worth reviewing as well, that make sure there's that open line of communication if someone has actually hurt themselves in their home environment, that gets communicated to you as the employer, both in the context of your reporting requirements, but also to allow you to assess that risk into the future, because that's certainly, we're all working in this new environment with some nice novel issues cropping up along the way.
Absolutely. All right, questions. So these were the ones submitted by people when they registered. So if you're listening and would like to do that in the future, please, I think it's quite easy to do at the time of registration. Question number one: if a worker has an adverse reaction from the vaccine and successfully claims for compensation, a one-off payment, through the Commonwealth Government COVID-19 scheme, can they seek further damages compensation with their employer if the vaccine was mandated?
This was a really good question. So we've had a look at that beforehand. For those who don't know, the Commonwealth Government scheme covers loss or expenses of $1,000 and above due to the administration of a TGA-approved COVID-19 vaccine or due to an adverse event that is recognised to be caused by a COVID-19 vaccination. This, again, is a novel area. our initial reaction to that is probably yes, but it's likely to be refundable as part of that. So, and again, all of those things we just discussed around proving what has occurred and whether it is in the course of employment certainly arise in conjunction to any Commonwealth scheme, because the qualification process will be different to that in terms of any work-related infection or vaccine reaction. I'm just going to have a look there. So, in going back to that Mount Arthur Cole case, in that case, a dismissal of a worker was found not to be harsh, unjust or unreasonable. They had consulted in the requirement for him to be vaccinated against COVID-19 if he wished to continue to work at the mine. And in that case, again, there was an upheld dismissal because there'd been procedural fairness in that space as well. So again, it's really going to come down to what people can prove in terms of what was required for work and what might have otherwise been something that someone has decided to do in their private life outside a specific work mandate or requirement to be vaccinated. So the second question.
Second question there is an employee covered under WorkCover if they work during a holiday and provide evidence of a suitable working area?
It's actually, I think, a very interesting question in the context of today, because I don't think we would have been asked that question 20 years ago. I think the answer to that is, of course, it depends, but certainly if someone takes their laptop on holidays and they're working and they sustain an injury, then it's quite probable that they'll be found to have been doing something in the course of their employment if they're actually working at the time. So that might be something to consider in your work policies, whether you do allow people to work on holidays, and if so, perhaps a reminder that you require any guidance that you have for a working from home policy, such as a checklist for their safe work environment, ought to be followed in that space as well. But again, if it's overseas or interstate, there might be other interesting complications arising.
Three, what happens if a worker is injured while working remotely when they are undertaking non-work related activities such as hanging, washing or going to a doctor's appointment?
I think we've probably covered off most of that in the paper. Probably if they're doing non-work related activities, it will be found to be outside the course of employment, and that WorkCover will not be a sort of a significant contributing factor to that in the context of their work. So in most cases, I think in that scenario, WorkCover would look very closely about whether that is a work related activity.
And again, sorry, that's probably going back to me before saying nuanced. If in doubt, put in the application and notify WorkCover, and we can have a close look at the circumstances. Number 4, what is an employer's liability in relation to ensuring workspaces are suitable for work to be undertaken remotely? For example, if approval is given and the workstation is not appropriate and then an injury occurs.
So I think this is probably covered off both by the Work Health and Safety Act provisions that are in the paper, as well as generally an employer's duty both under the Act and at common law to ensure a safe place and system of work. So certainly I think in most cases a court would accept that the employer's responsibility does extend to work being undertaken remotely, particularly obviously if permission has been given for that to be a permanent arrangement. So I know some employers have done sort of checklists, some require other evidence in terms of what a work from home process looks like, and other employers have provided, in fact, the whole workstation at home in terms of the work being undertaken. So there's various responses to the level of risk, but certainly I think broadly the answer to that is that there will be liability in that space.
Okay, a common law with that test that you put up there, it's a fairly low bar to steps that an employer can take. As you were just saying, we here at WorkCover to work from home have to take photos of our workstation with us sitting in the seat and with us not sitting in the seat, and it gets assessed, and if it doesn't look right, we get feedback and have to adjust. So there are certainly steps employers can take to reduce the risk of harm to their people.
And I think if you do receive a complaint where someone's saying, I've got neck or back pain and I am working at home, that should probably trigger further inquiry and perhaps a more specific risk assessment or undertaking in terms of what their work from home environment looks like.
That's leading into the next
question.
It does. Now. Sorry, work from home agreements also ask for photos as well, i.e. office area, desk setup, and areas that would be considered break areas such as kitchen, dining table, bathroom.
Certainly, I think the office area and desk setup, the kitchen dining table, if they're working at it, yes. In terms of what they might be doing in their kitchen and bathroom, that takes us into that interesting area of whether a recess claim will apply in the home environment, because it's not a place of employment that's controlled by the employer. So I'd probably be a little more cautious about asking for photographs of their more private areas of their house, but that could perhaps be dealt with more tactfully by checklist. But I think actually an area that's been underestimated as a risk at home is the electrical safety side of things, because in our office, at least, all of our stuff is tagged every year and inspected. So there are those sorts of things that perhaps are also better dealt with by a checklist rather than a simple photograph of their work environment.
The last one up there, we've got a couple more that have just come in, but the last one up on the screen, how do claims arising from work from home circumstances affect premium? That's probably more for me, isn't it? I thought this was quite obvious, and then had a moment this morning thinking I should check, but it would affect premium. If someone suffers an injury whilst in the course of employment, it's an injury whilst in the course of employment. That's set in the Gazette. The Gazette is where journey and recess claims are specifically excluded from premium impact, and there's no similar provision in there for work from home injuries. Of course, I shouldn't speak for the future, but we're all seeing what happens in the work from home space as it becomes more and more common. Right now, work from home injuries are premium impacting. We've had two questions come in, so that you'll be on the spot because you haven't seen them, but I'll just read them out to you. If a worker has sustained an injury at work and then been cleared of the injury for a period of time, but later aggravates the injury at their home outside of work hours, could an employer be liable for re-aggravation?
Well, as you saw with the initial definition of injury, it certainly can include an aggravation or exacerbation. So, but the concept of compensation under the Act, as we've seen at home, is definitely linked to being in the course of employment, and with employment being a significant contributing factor to that injury. So again, that would loop back to they would have to actually be undertaking work at home at the point where the aggravation or exacerbation did occur. Obviously, again, there's difficulty in proving what they might have been doing at home when this happened, but most workers, as I said, at home are hopefully working on a sort of office-based thing. So if there's a significant back injury that might perhaps have been occurred lifting, then that would be less likely to be in the course of employment. But yes, broadly, if it's shown and the worker is accepted that they were undertaking the duties of their employment at the time, an aggravation injury would certainly be capable of acceptance.
We're pretty good. When we get aggravation applications come in for statutory compensation, we're quite good at investigating those and trying to really understand what's caused this new set of symptoms. Was it work-related or was it something else? The second and the final question we've got, is there any case law relating to workers who work full-time virtually for a Queensland employer but live interstate or overseas? Are they considered a Queensland worker?
Yeah, possibly. I said to Tim before we started, that was a whole heap of provisions we didn't really have time for today, but there's specific provisions in the Act for interstate and overseas work, and it's a cascading series of tests as to where their usual place of employment is. So that would be the test that would be applied in that circumstance. So again, that would be something specifically tailored to that individual's circumstances, but we do see cases where overseas employment is accepted as being related to the Queensland scheme.
I think, because I had to look this up recently, that there have been a couple of relatively recent state of connection cases.
Yes.
So maybe we can find a way to work that into, just links to those into the slides, because they're an interesting read, and as you say, it's called a cascading test, which I quite like. So you work your way down the questions, and the final one I think is where the employer is based. So that's the last thing.
Yes. So if you had a permanent contract with someone overseas, it can get down to that last test. So what we might do when we send the paper out is we'll give you the links to those provisions in the Act and the recent decisions as well.
Thank you very much. And that was the end of our questions. So that's all the time we have, I suppose. Thank you very much. That was an excellent presentation. So as we said at the start, this has all been recorded. We'll send out the link to you shortly via email, and we'll upload it to the YouTube channel, where you can also find all our previous webinars in a dedicated playlist. We'll also send out a survey so you can send some feedback on this session. The sessions generally, or even if you want to sneak in there, I suppose there's probably free space. You could ask for particular topics for webinars in the future, because we're always interested to know what you want to hear about. If you'd like to attend any more webinars, keep an eye out in your email, on LinkedIn, or the events page of the WorkCover Queensland website. I don't know if I sufficiently thanked you, Yvette. Thank you. We appreciate you putting in the effort and for the terrific talk, and thank you, Elise, as well. That's all from us at WorkCover. Thank you very much for listening in today.